Hi, everyone. Thank you for joining us today for Constangy's webinar from job postings to pay data, mastering today's pay transparency requirements. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Their contact information will be included in our post-webinar follow-up email. This program is approved for SHRM and HRCI credits. We will be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Cara, Crotty, and Rayner Mangum.
Great. Thank you so much, Victoria. Hello, everyone. Welcome, and thank you for joining us for today's webinar, From Job Postings to Pay Data, Mastering Today's Pay Transparency Requirements. For those of you that are still joining, Victoria did advise that we will be sharing the presentation and a recording tomorrow, so you'll be receiving that after the presentation. But I am Cara Crotty, a partner in the Columbia, South Carolina office of Constangy, and I co-chair our practice groups on EEO, contractor compliance, and DEI compliance. And I'm here with my colleague, Rayner Mangum, senior counsel in our Denver office. And being in Colorado, Rayner has really been on the forefront of the pay transparency lines and the developments there after Colorado passed the first comprehensive statewide requirements. So she's definitely become a subject matter expert in the world of pay transparency. So I'm thrilled to be presenting with her today. Just a couple of disclaimers before we jump in. First, obviously, we're not providing legal advice for any specific organization. We're always happy to help our clients and companies with specific legal advice, but we're not providing that during today's presentation. We're also going to keep our comments and our overview today nonpartisan. We're not taking sides, and this is sometimes be a political topic. I think you'll see when we talk about the different jurisdictions that have pay transparency requirements. There is a bit of a divide between the red and the blue states, but we're here just to provide information and not to be partisan. And then my last disclaimer is to keep in mind that the requirements in specific jurisdictions are going to vary. Rayner is going to be providing a really good overview and outline of what the different pay transparency requirements are. But as always, the devil is in the details. So if you have questions about any particular jurisdiction, you want to make sure that you look at those laws in greater depth. So today's session, we are doing a deep dive into the pay transparency pool, so to speak. And a lot has changed in this area in the last year or so. We now have mandatory pay range posting laws in multiple states as well as localities. We have internal mobility transparency requirements, aggressive pay data reporting mandates, and along with that, of course, a growing wave of enforcement and litigation. So our goals today are to help you understand what these various legal requirements are across the different jurisdictions, identify operational pitfalls that could create risk for your organization, build a repeatable and scalable compliance framework to ensure that you're complying with these requirements, help you prepare for pay data reporting in certain jurisdictions, and then finally anticipate litigation and enforcement trends. So this is certainly we intend for this webinar to be practical, and we hope you will walk away with some concrete steps that you can take to ensure compliance. So we'll start off talking about the new normal in pay transparency. And I'm going to start with this slide about the earliest known want ad. As it was very coincidental, but as I was preparing the slides for this presentation, I just happened to read an article that was the whole article was about how job ads have changed over the years. And it found, according to this professor of anthropology at Rice University, the very first known want ad in the US was published in the Virginia Gazette in 1752. And it read, "A sober person, well recommended, who hath been used to the employment of an oysterman on York River, may meet with good encouragement on applying to Benjamin Bryan." So I thought that was a good little piece of trivia for us to start out the presentation. But obviously, things have changed quite a bit since the 1752. So how do we get from there to where we are today? Well, clearly, there's been an intense focus on pay equity in the past 10 to 15 years, if not longer. And there's been an increase in enforcement efforts by federal agencies, the EEOC, the OFCCP, as well as state and local governments. We've seen more lawsuits by private plaintiffs alleging pay disparities based on protected characteristics. And of course, then employee expectations have shifted. Candidates now expect to see pay ranges in job postings. And employees expect to understand how their pay is set and how they compare to their peers. And obviously, regulators also expect employers to have well-documented practices when it comes to compensation. And then we see a domino effect. When large respected companies start implementing certain employment practices, then those trickle down to other employers. And then often, to remain competitive in the labor market, those practices just become standard across the industry or different geographic areas. So there's, like I said, this domino effect. And these policies and practices just end up becoming standard. Of course, that's been accelerated with the pay transparency laws that we're going to be talking about. And all of these developments, I think, have certainly led governments to identify ways to close the wage gap between men and women, and to reduce potential discrimination in pay. One method that we've seen are laws prohibiting employers from asking about salary history. And the theory behind that is that women are more likely to have experienced pay discrimination in the past. And so if an employer bases compensation on prior pay, then the effects of that discrimination are just going to be perpetuated. So I think that kind of sets the landscape here. I'll turn it over to Rayner, who will walk us through the existing pay transparency landscape in the US.
Yeah, thanks, Cara. So changing topics here. First, we're going to look at the NLRA and the requirements there. Under the NLRA, employers cannot implement pay secrecy policies that prohibit employees from discussing their wages. Doing so would be unlawful because it would restrict employees' right to engage in protected, concerted activity. The OFCCP also had a pay transparency requirement, which was tied to Executive Order 11246. That executive order has now been rescinded by President Trump. So while that is now gone, the requirements of the NLRA remain in force. Next, we're going to talk about the states that have enacted laws that require pay transparency in job postings. At present, that is California, Colorado, Hawaii, Illinois, Maryland, Massachusetts, Minnesota, New Jersey, New York, Vermont, Washington, and also DC. Note, too, that several cities or counties within New Jersey, New York, and Ohio have also enacted pay transparency requirements. Some of these localities require pay disclosures and job postings in a manner that's similar to the states that have enacted pay transparency requirements, while others require pay disclosures not necessarily in job postings, but instead only upon an applicant's request or upon the employer making an offer. Also be aware that additional states have either already enacted or are considering enacting pay transparency laws. These include Delaware, Maine, Montana, Oregon, and Virginia. All that to say, this landscape is continually changing, and it's important to keep an eye out for newly enacted legislation. Now we're going to look at what's required among the various states that have the pay transparency job posting requirements. This chart details the states that have job posting requirements, which employers are subject to those requirements, as well as what's generally required to be disclosed in each state. As you can see, at a minimum, all of the jurisdictions with pay disclosure posting laws require employers to detail in job postings the pay range that will be offered for the role. But be aware that jurisdictions differ as to which employers are covered by the law, meaning how many employees an employer would need to have before the requirements of the law apply, and then also whether that number of employees have to be located within the particular state or not. Jurisdictions also differ as to whether additional information, such as benefits, must also be included in the job postings. So first, what is a pay range? A pay range is the minimum and maximum pay that the employer reasonably believes, in good faith at the time of the posting, that it will pay for the position. This is generally based on factors such as market data, internal equity, job value, budgeted compensation, and compensation philosophy. In some jurisdictions, other forms of compensation, bonuses, commissions, tips, etc., must also be disclosed. Common pitfalls here would include detailing a pay range that's extremely wide, so saying something like $50,000 to $200,000, providing a pay range that has no lower or upper point, so saying something like pay will be up to $75,000, providing a range that's inconsistent with pay for existing employees, having managers or recruiters who misstate the pay for the position when interviewing, or providing a range in a separate link or in a QR code. Note, though, that for this last one, this is actually permissible in many jurisdictions, but it's subject to varying requirements. So in Washington, for example, you have to go ahead and provide a general description of pay and benefits in the posting itself, but then you can provide a link to a more detailed description. So just make sure to look at the governing jurisdiction's rules before using something like a link or QR code to provide the required information. Note here as well that some jurisdictions require that if the posting is one where the employer would consider hiring someone of varying experience levels that would slot them into a range of different job titles, the employer needs to detail the various job titles and pay ranges that it would consider providing. So this could look like detailing in a job posting that if someone's hired at account analyst 1, they would expect to be paid something in the range of $60,000 to $70,000. If they were hired in an account analyst 2 role, the pay range would look like $70,000 to $80,000, etc. Next, for the states that have this requirement, we're going to look at the benefits disclosure requirements. Benefits typically include things like medical and other insurance, profit sharing, retirement benefits, paid time off, stock options, and other benefits that must be reported for federal tax purposes. Make sure to actually detail all of the benefits that will be provided rather than saying something like health insurance, paid time off, etc. All of the benefits do need to be detailed. However, benefits typically do not include things like gym memberships, employee discounts, and other minor perks. Note that where an employer includes things like paid holidays and PTO as part of the benefits package, some states require benefits disclosures that include the employer listing the specific number of paid holidays or the specific amount of PTO that will be provided. So that could look like saying 12 paid holidays per calendar year or 8 hours of vacation leave every month. Note that some states have additional job posting requirements as well. In Colorado, employers must also provide information regarding how to apply, as well as a good faith estimate of the date the application window for the position is expected to close. There are narrow exceptions there for things such as evergreen positions, where the employer would instead state that it accepts applications on an ongoing basis rather than giving a cutoff date. New York also requires that postings contain a job description if one exists. In certain limited situations, a job description may not be required because the name of the position or the title clearly conveys the full extent of the duties. So for example, a job posting for a dishwasher who will only be washing dishes would not need a more detailed job description. Now we're going to look at the application of the disclosure requirements to remote roles. In many states, if the position is a remote role that could be filled by someone within the jurisdiction's pay disclosure requirements are going to apply. In addition, be aware that in some jurisdictions like New York, the pay disclosure requirements apply even if the role will not be filled by someone working within New York, so long as that person will be reporting to either a supervisor or to a pay site within New York. Potential strategies for remote roles that could be filled by candidates in many different states would include posting ranges for different geographical areas or posting state-specific ranges, and also, as we'll talk about a bit later in the presentation, creating a standard posting template that complies with all governing jurisdictions. Note that employers cannot avoid particular states' pay disclosure laws by stating that they will not consider candidates from the states which have these laws. Colorado has additional requirements, including that employers inform Colorado employees of all job opportunities company-wide. Note that this includes out-of-state roles, as well as roles for which Colorado employees would not be qualified or would not have any interest in. The exceptions to this requirement are fairly narrow and include career progression promotions. These are regular or automatic promotions based on time in a specific role or other objective metrics that employees can satisfy without competition. Career development promotions are also excluded. These promotions simply update the employee's job title or compensate the employee to reflect work performed or contributions that have already been made by the employee. Acting, interim, or temporary hires are also excluded. Notice is not required for these acting, interim, or temporary hires for positions of up to 9 months, unless the same position was held by an interim or a temporary hire for 7 months of the previous year. Lastly, there's a limited exception for employers who are physically located outside of Colorado if they have fewer than 15 remote-only employees working in Colorado. These employers are only required to provide notice of remote job opportunities until July 1st, 2029. And then some jurisdictions like Hawaii expressly exclude disclosure requirements for internal transfers or promotions. A few more Colorado-specific requirements. With limited exceptions, Colorado requires post-selection notices. So within 30 days of hiring, employees with whom a selected candidate will work with regularly must receive a post-selection notice detailing the selected candidate's name, their former job title if they were promoted internally, their new job title, and information regarding how employees should demonstrate interest in future similar opportunities. Employers are also required to provide career progression notices to employees who are in career progression roles. Career progression is defined as a regular or automatic movement from one position to another based on time in a specific role or other objective metrics. For these positions, employers must disclose to employees holding these roles the requirements for progressing and the compensation, benefits, the full-time or part-time status, the duties, and access to further advancement within each role. And this should be provided shortly after employees begin any position with career progression. Separate from the job posting requirement, be aware that certain states like California, Connecticut, Massachusetts, Nevada, and Rhode Island require employers to provide current employees and/or job applicants with the pay scale for their position upon their request. So who can sue for violations of the pay disclosure requirements? The answer is that it depends. In many states, it's the state's Department of Labor that has the authority to investigate alleged violations, but in other states, there is also a private right of action. Washington, in particular, does provide a private right of action, and their Supreme Court recently held that in order to qualify as an applicant who can sue for an alleged violation of the state's pay transparency law, the plaintiff must have applied to a specific job posting, but they're not required to prove that they were a bona fide or a good faith applicant in order to obtain remedies under the statute. Thus, the only requirement is just that they applied. Lastly, looking at the effect that the pay transparency laws have had, you can see from this graphic that the effect has been pretty dramatic in terms of increasing the number of job postings that are disclosing pay. Nationally, we went from under 20% of postings that were disclosing pay in late 2020 to over 50% in late 2023. And in Colorado specifically, we went from under 25% to over 80% in that same time frame. Okay, so now I'm going to turn it over to Cara to talk about pay data reporting requirements.
Thanks, Rayner. Yeah, that's a pretty significant increase in salary ranges in job posting. And I would say it's becoming, I think, fairly unusual to see a job posting without a pay range included, given the number of employers that have to comply with one or more of those requirements. All right, so let's shift to pay data reporting, which is certainly expanding and becoming more complex, except for a brief period when the EEOC required employers to submit component to pay data. Pay data reporting is up to the states, and we currently have a couple of states that have forged ahead and are requiring employers to submit pay data. So we're going to cover California and Illinois. They're currently the only states that mandate the submission of pay data. However, and I don't have a slide on this, it happened just recently, but keep in mind that New York City just passed over the mayor's veto a pay reporting ordinance. So under that ordinance, private employers with 200 or more employees in the city will be covered, and they will have to submit annual reports that detail their number of employees broken down by race, ethnicity, sex, and the presumably the EEO1 occupational categories. The report will be modeled after the EEO1 component to pay data report. And from what I can tell, there's no clear effective date yet. Again, the ordinance was just passed, but it looks like it'll probably be 2027 before the submission of pay data is actually required in New York City. But for California, this was really one of the, I think the first state requiring pay data reports for employers. It came about with the demise of the EEO1 component 2 pay data report that the EEOC had in place until President Trump rescinded those requirements. But this pay data report applies to private employers with 100 or more employees and at least one California employee. Covered employers are required to report their pay data on all employees that are assigned to a California establishment or who work in California. So by establishment, employers have to report for each employee the EEO1 category, race, ethnicity, sex, the pay band that they fall in, total hours worked, and median and mean hourly rates. The details of who to include and who not to include and how to report all that information is fairly complex. Fortunately, California has, I think, a pretty robust set of FAQs to help guide employers in understanding how to do all that. So I definitely commend that to your study should your organization have to submit this report. And another item of note for California is that in 2027, they are expanding the occupational categories. Instead of using just the EEOC's 10 EEO1 categories, that the state is expanding that to 27 different job categories. So keep in mind, by the reporting deadline in 2027, covered employers will need to have matched all of their job titles to one of these 27 job categories for purposes of reporting. The report is due on an annual basis on the second Wednesday of May. So obviously the exact date will change year to year. In 2026, that falls on May 13th. So mark your calendar if you have not already done so. But you won't be able to start working on the data really for another couple of weeks. You want your 2025 payroll information to be complete. Another thing of note for California is they have basically the same type of report for labor contractors. So in addition to employees, if your organization utilizes labor contractors from another entity that come and work on your site, then you are obligated to file a very similar report for those individuals. And California is actively auditing and imposing penalties on employers who have not responded to the pay data report. So next is Illinois. Illinois has the Equal Pay Registration Certificate. This applies to private employers with 100 or more employees in Illinois. So it takes a few more employees in the state to be covered, as opposed to just the one California employee. So you have to have 100 or more employees. And then once you're covered, you have to provide individual employee level data for the prior year, separated by race, ethnicity, and sex, and include date of hire, total wages, hours worked, and most confoundingly are job changes. I think that's the one element that is most difficult for employers. Illinois requires you to include any job changes that an employee experienced during the year. So if they were an accountant 1 beginning of the year and they get promoted to an accountant 2, you have to show that change. And then you are supposed to show the hours worked and pay received in each one of those different positions. And my clients have found that to be particularly challenging because we don't pay employees by the date they change their position. We pay them by payroll, or payroll period. So delineating exactly how many hours and the wages that someone had in multiple positions during the year can certainly take some time. It's not likely that you're going to have a report that can just spit that out. As far as the deadline for the Illinois pay registration, it's going to be different for different companies. The reporting requirement is every other year, so you'll have to do it on a biannual basis, but your deadline will depend on when you filed for the first time. So it's kind of a rolling deadline for every organization. It's not going to be the exact dates for every company. And then Illinois requires this equal pay certification. You have to provide a compliance statement that is signed by a corporate officer, legal counsel, or another authorized agent. You have to certify that the company is in compliance with the Illinois Equal Pay Act and other federal and state discrimination laws. And I think the second bullet point here is the most challenging aspect of the certification. You have to certify that the average compensation for female and minority employees is not consistently below the average compensation for male and non-minority employees within each job category. And you are allowed to take into account factors that would affect pay, such as seniority, skills, experience, education, location, training, etc. So think about how you would be able to accurately certify that. One, you have to look at what the average compensation is for females and males and minorities and non-minorities in each one of your job categories. And if the average for females and minorities is consistently falling below the average for the other group, then you're going to have to know whether or not those legitimate factors are explaining the difference. And I don't think an employer can do that without doing a detailed analysis, probably a multiple regression analysis, depending on how large the grouping is. But that's something to factor in and when you're preparing your equal pay certification, to ensure you have the time to do that type of analysis so that you can accurately certify that is the case. You also have to certify that you're not restricting employees of one sex to certain job classifications, and that you make decisions regarding retention and promotion without regard to sex. You are also certifying that the wage and benefit disparities that are identified are corrected to ensure compliance with the Illinois Equal Pay Law and other statutes that prohibit discrimination. And then these last two bullet points are more open-ended, and I believe Illinois provides kind of multiple choice options to choose from, but you have to disclose how often you are evaluating wages and benefits, and also what you use to determine the level of wages and benefits paid to employees. So for example, maybe you rely on market rates or internal equity or something along those lines, but you have to select what it is that you're using to determine compensation. All right, let's talk risk. Pay transparency now makes disparities much more visible, and employees are certainly comparing the ranges that they see in job postings to their own compensation. So discrepancies or differences quickly become noticeable. And we've seen plaintiffs' lawyers are using job descriptions to file lawsuits arguing that protected groups are underpaid, or that the employer is either inflating the wage ranges or providing inaccurate information. But focusing on the risk relating specifically to pay transparency in job postings, Colorado in particular is kind enough to publish the data on its enforcement efforts. I think it does so very proudly. And I think this is updated on probably a monthly basis. This snip here is from the November 3rd, 2025 data. And as of that date, hopefully the slide's big enough, but I provided the link there so that you can find it. And there's more information on this site just than what we have on this slide. But just to give you an overview, the total number of complaints filed in Colorado since the inception of the law in January 2021 is almost 2,400. So certainly that's not a minuscule amount, I don't think. And then if you'll note down below, the citations with fines. So there have been 10 employers that were found in violation and included a fine. And the state of Colorado collected almost $500,000 from those 10 employers. And again, it details the information on their website, but one of those employers was responsible for almost $300,000 of that total just by itself. So most of the fines are much smaller, but I think it's certainly in the beginning, Colorado was, I suspect, intending to make a couple examples of employers to kind of help highlight their stance and position around the importance of compliance. So certainly there are significant penalties in Colorado through the state's enforcement efforts. In Washington, as Rayner mentioned, there's a private right of action for individuals, and there have been multiple class actions filed alleging that employers are either posting inaccurate ranges, they're listing ranges that they never intended to pay, or they're not disclosing the full compensation components or full benefits. And so there have been several different settlements of those class actions in Washington state, ranging from $360,000 up to $6.3 million. So obviously those are very serious types of claims, and noncompliance is obviously very costly in the state of Washington. And the statutory penalties vary from jurisdiction to jurisdiction. So like, again, like Rayner mentioned, a lot of these laws are enforced by the State Department of Labor. And so those will be the entities that impose fines or penalties against employers for violations. So in California, for example, the penalties can range from $100 to $10,000 per violation. In Massachusetts, it's $500 to $25,000 per offense. And then in New York City, it can be $250,000 per violation. And the amount really typically will depend on the number of prior violations that the employer has been cited for. So the first go round, if you get cited, you're going to be at the lower end of the scale. And then as the number of violations increases, you'll end up at the higher point. So certainly very hefty penalties for employers that are found in violation of these state statutes. Rayner, I'll pass it off to you again.
Yeah, so now we're going to cover building compliance frameworks. So first, employers need to develop a compensation philosophy, and we've detailed here a list of factors that we would recommend considering. Certainly how jobs are evaluated, how jobs are benchmarked, how salary ranges are established, how pay decisions are made, how internal equity is ensured, and how geographic differentials are handled. Employers should also establish job architecture and create job families, levels within families, job descriptions, the criteria for advancement, and range consistency. Employers need to be very mindful about maintaining documentation. This is extremely important, especially if any issues should arise down the road. And so employers certainly want to be able to defend the pay ranges that have been provided and be able to show that they were indeed the good faith estimate at the time of the posting. We would also recommend that employers create standard posting templates, maintain documentations on job descriptions and any updates that are made to them, and certainly that they maintain documentation of all external and internal job postings, as well as any updates that were made to the postings. In preparing job postings, we would recommend that employers take a 4-step process, first assessing the organizational footprint, then analyzing the posting requirements in applicable jurisdictions, then developing a posting template that complies with all applicable jurisdictions, being sure to comply with the most onerous of all the different jurisdictions' requirements, and then implementing a compliance process and updating it as needed. It's also very important that employers manage outside recruiters, as employers are often liable for recruiters' actions. Here we recommend tightening recruiter agreements, including indemnification provisions, providing standard posting language to recruiters, requiring pre-approval from recruiters for postings before they're issued, monitoring job boards, and documenting any corrections that are made. Lastly, we would recommend that employers leverage technology. This can simplify the process and also reduce the possibility of human error in creating job postings and pay ranges. So here, employers can use human resources information systems to tie salary ranges to job codes. They can automate posting templates and the language. They can integrate ATS with posting templates and analyze compensation for disparities.
All right, and we'll spend the end here talking about some practical takeaways. I don't think I see any questions in the chat yet, so now's your time. We'll have time to cover some questions at the end, should you have it. But what are the practical takeaways for organizations when it comes to these pay transparency posting requirements and the pay data reporting? As Rayner was just mentioning, I think one of the most important aspects is developing a compensation philosophy and your job architecture, because this is going to guide so much about your process, right? The your compensation philosophy is going to determine how ranges are set for different types of jobs and how we are grouping similar jobs together. And when you think about compensation and ensuring equity, that's really the most important piece. We want to and have to pay similarly situated individuals the same. Generally, obviously, we have factors that can explain reasons for differences, such as time in job, seniority, performance, those types of things. But the range generally is going to guide how we determine compensation. And different organizations are going to develop different philosophies around this. But certainly with the advent of the posting transparency for salary ranges, that not just applicants are scrutinizing that pay information, but your existing employees are as well. Also, like Rayner mentioned, I think it's really vital for employers today to create a standard job posting template. Most employers are recruiting from around the country. So unless you're a smaller employer that only is going to be looking to recruit in a state that doesn't have pay transparency requirements, or doesn't have employees in one of those covered states, then you really want to develop one template that you can use on an everyday basis that's going to comply everywhere. Otherwise, it's just, I think, would be an overwhelming headache for you. So hopefully today's information will give you a starting point with what you need to include and how you need to include that information in your job posting templates. And certainly where you have employees in the states that we've identified, do a deeper dive into those statutes to see what the fine print says and make sure you're including all the necessary information. And typically you want to, as we've stated, have a job posting template that is going to comply with the most restrictive or most detailed requirements of the jurisdiction that has the most requirements. Sorry, that came out a little convoluted. But once you have that standard job template, I think you'll be set and will be able to more efficiently post your jobs and do the hiring then that your organization needs. Educate recruiters, another vital, important aspect of your compliance process. They're the front line of getting these job ads out. And so we want to make sure that they understand the ins and outs of the pay transparency requirements so that we're not inadvertently posting positions or posting advertisements for jobs that aren't in compliance. I think it was certainly more understandable 2-3 years ago when these laws were new, that there was a lot of confusion and uncertainty around what needed to be required in postings. But certainly now we want to make sure that our recruiters are well versed in these obligations. Analyzing employee compensation, I think, is also an essential component of an employer's compliance process. We haven't talked about that as much today, but you are submitting your pay data to the state governments who are analyzing it. They're looking for pay discrepancies that potentially are not explained. We are posting our job ranges for anyone in the world to see when we post an ad. So there's so much more information out there that individuals can use to triangulate whether or not they might be paid inequitably. So certainly it's advisable to be analyzing your compensation to see if you have disparities that are unexplained. And hopefully if so, you can correct those before you're submitting your comp data to the government agencies. But when you analyze compensation, you want to be sure that you're conducting those analyses under the attorney-client privilege. You do not want them to be discoverable. So it's really important that you engage either an internal lawyer or your outside counsel to be involved in the analysis and providing legal advice around what the analyses show. Make sure that those privileged analyses are separated from other business documentation. You want to make sure that we maintain the privilege by limiting who has access to it, and with whom the information is discussed. And another cautionary tale is based around avoiding references to your privileged analyses in external communications. A federal court recently ruled that an employer's pay equity analysis was not privileged and was discoverable in litigation around a pay disparity issue because that privileged analysis was referenced in the company's annual report. The annual report contained information about the analysis itself. It basically referenced or stated that women in the organization earned an aggregate, I think it was 98% of the pay earned by men in similar roles, and the same type of analysis for diverse employees compared to white employees in similar roles. And the court ruled that alone, that just kind of what I think is a fairly limited disclosure about the analysis, waived the company's privilege of that pay equity analysis. So be very mindful of that when you are conducting employee compensation analyses. And then last but not least, monitor new laws in states and localities. State and local laws are continuing to proliferate in this area. So it started with Colorado, and as you could see see from the slides Rayner went through, there's been kind of a building momentum of more and more states and even cities getting into the pay transparency minefields, shall we say. And I think we see that happen a lot when there's kind of a void in the federal landscape, where we don't have a federal law or even a federal regulation, maybe that applies to federal contractors. When we don't have something like that, the states tend to step up and create a diverse patchwork of various laws and regulations that employers have to comply with, which of course just makes it all the more challenging because, as you've seen, there are certainly a variety of differences that can make it difficult to have one standard approach when it comes to compliance. Those are our takeaways. So let's switch and see if we've got some questions. But here, both email addresses for Rayner and I, as well as, most importantly, the codes for your credit for SHRM or HRCI. Let's see if we've got some. Yes, you'll get copies of the slides. How about this one, Rayner? What do you see as an average timeline to move from lower maturity to higher maturity with comp transparency? It's a journey for sure. So I think the question is asking, like, within an organization, like how long would you expect a company to take from kind of the beginning compliance aspect to becoming fully compliant with all of these different laws? That's how I'm reading the question. What are your thoughts on that? Put you on the spot.
Yeah, no, that's a good question. I think for most clients, we've seen it sort of develop as the laws do. Like you were saying, Colorado has some of the most onerous requirements, and those have been around and honestly been changing and developing over the course of the last few years. And other states that have followed, those have materialized in the last few years as well. So I would say my experience with clients has just been that, as the laws change, they have to change their processes and compliance frameworks. And that's all developed over the course of the last couple of years.
Yeah. Yeah. I think it's a definitely continuum for sure. But the other thing I would add is that you don't have a lot of runway anymore, right? These laws are in effect in these jurisdictions, and they're expecting compliance now. And so I would definitely, if you are covered by any of these state laws, make sure you're doing your best to comply immediately. Are there any job titles excluded from pay transparency requirements in states where pay transparency is enacted? This is a good one. Actually, I was emailing Rayner about this question earlier today. And so one thing I found is there's a kind of a dichotomy. There are some states, not many, but some that have the mandatory posting requirement, meaning if you have an opening, you have to post it. And then there are the other states that are just requiring the pay transparency if you post the job opening. So that's one thing to keep in mind. But Rayner, are you aware of, I know there are no job titles that are specifically included, but can you talk about the Colorado exception for confidentiality?
Yeah, so there's a limited exception in Colorado for notifying of a job opportunity, and it's where the person who's going to be separated doesn't yet know. So there's a limited exception there, just where there's that need for confidentiality.
But that's the
And
only reason it gives you, right? Which I think is very narrow.
right, yeah, the exceptions there are extremely narrow, and of course we have the temporary hire exceptions and some other also extremely limited exceptions in Colorado as well.
Yeah, yeah. I think the other state, I think it's New Jersey, that has the mandatory posting requirement if you have an opening. And I don't think its law, from what I've seen, addresses any type of exception for, a confidentiality. Say, you're posting for a position that you're going to eliminate. I haven't seen that. If you post for a 100% remote position, do you need to include the salary range, because it could have a Colorado or other, insert your state, various state applicant?
Yes, so if the position is one that could be performed by someone in Colorado, all of the disclosure requirements do apply.
If you're covered by the Colorado law.
That's right. Yeah.
There was a question about Massachusetts. I think maybe that was about, could be referencing the pay data reporting. My understanding about Massachusetts is currently it's not requiring pay, and just more like an EEO-1 report, where you're providing race and sex information for your employees. I think that is all the questions we have. So we will conclude. Thank you so much for joining us today. It was our pleasure to speak with you. Hopefully the information was helpful, and please reach out to us if you have any questions.